Back to the House Judiciary Committee and continuing testimony on S12. And we have Jennifer Collin, General Counsel, Office of Professional Regulation, to speak with us. So thank you for being here.
Thank you so much for inviting us. We appreciate it. I do have written copies. This was just posted, so if you'd prefer to have a paper copy.
Yeah, I think a lot of us do.
Okay, great.
The roots, so that would be great.
Oh.
Yeah.
Thank you. I think if we make it around. No. Great. So Jennifer Collin, General Counsel from the Office of Professional Regulation. Thanks so much. I haven't had the opportunity yet to testify in front of y'all, so it's exciting for me. Thanks. In our testimony today, we're going to provide you with some information about how the Office of Professional Regulation works and talk a little bit about how we use criminal histories and background checks in our licensing and disciplinary processes. And then we're going to talk about 3 suggested revisions to the language in S12. And the purpose of those suggested revisions is to ensure that regulatory agencies like OPR won't be held responsible for inadvertently running afoul of the expunging and sealing requirements in S12. It's important to start off by saying OPR does support S12. It is one of our priorities to remove unnecessary barriers for folks who want to get professional licensing. We've done a lot of work in the last few years to do that through different processes that we've implemented. So we always like being a part of this, and we do support it. OPR is an umbrella agency. We have 40 staff, and we regulate over 50 professions. We have about 84,000 individual and business licensees that we regulate in the state. So our professions, it's a wide range of professions, everything from healthcare professions like osteopaths, nurses, dentists, mental health practitioners, to other types of professions. We have a lot of real estate related professions, home inspectors, real estate brokers, appraisers. And then we have others like tattoos, barbers and cosmetologists, acupuncture. So it's really a wide array of professions that we regulate. We are a public protection agency. And so we enforce our public protection mandate by ensuring that people that enter the professions we regulate meet the minimum qualifications to practice in those professions safely. And we also have enforcement processes so that when someone is not on track and maybe engages in some unprofessional conduct, we have enforcement processes that are really geared towards ensuring that someone can remediate that by getting education or other sanctions. Maybe they need to be on conditions for alcohol and drug testing or whatever those conditions are to ensure they can be a safe practitioner, and then getting them back in the workplace, because that's, we're kind of always balancing the public protection need and the ability of someone to practice in their chosen profession without government interference. So we think we do a good job of that balance, and S12 is kind of really consistent with maintaining that balance. So let me just explain a little bit about our licensing and disciplinary processes and how we interact with criminal information, information about someone's criminal history. So when we are in the process of doing licensing determinations or pre-licensing determinations, in all of our professions, we ask someone, have you ever been convicted of a crime? And if you have been, please provide us with documentation showing us what that conviction is, and then explain the circumstance. So again, we're balancing the title of the crime or the elements of the crime, and then really what's the context that this happened in. It's kind of that humanistic approach. We have other professions where we do criminal background checks, fingerprint supported criminal background checks. So we get criminal information that way as well. And so when we are aware that someone has a criminal history, they were provided with documents that show a conviction. And then we have basically a licensing and enforcement process where we review that criminal history. We look and see if it's related to the practice of the profession. There are some professions where, for example, a fraud conviction, that might not be, if you want to be a tattooist, having committed a financial fraud on somebody might not be as related to the practice of the profession. Whereas if you're a real estate broker, or if you're in some other profession where there's an accountant or something like that, there's a stronger tie to that conviction. So we kind of take it on a case-by-case basis, and we look at the criminal history. We have licensing and enforcement involved in that discussion, and then we determine whether it's related to the practice of the profession, if it should be a bar to someone entering the profession, or if someone could enter the profession, but there's still a need to protect the public by making the public aware. So we might allow someone to have a license, but then like conditions are imposed when they get the license so that the public can see, it's like disclosure to the public. This is an experience that this practitioner has had, and you should be, you can be aware of that and consider that however you want to consider that. So that's kind of how on a day-to-day basis we interact with those records. If there is some sort of disciplinary process that happens, if we decide that license should not be granted, or there's a need to protect the public and that license could be granted with conditions, there's a whole disciplinary process around that. And either a board or an administrative law officer hears that case, and the licensee gets the opportunity to appear and be heard and give testimony. And then the administrative law officer or the board, they make a decision, a licensing determination or a disciplinary determination. And those are public processes. So if a board or an administrative law officer determines that there should be some discipline, there's going to be an order that comes out of that, and that order is posted on our website. That is a public document. And in that case, the pleadings and the materials leading up to that public order, those are also public records. They are not confidential once someone has been charged and found to have engaged in some sort of conduct that merits that sanction. So, we get a lot of public records requests for discipline about licensees. So when we do, we're disclosing disciplinary records. Sometimes those do include, criminal convictions, or, criminal convictions might be referenced in a disciplinary order. So, S12 is an important and impactful statute for us, because when we get an order that something has been expunged or needs to be sealed, we want to make sure that we do that effectively so that we're not inadvertently, disclosing information that shouldn't be out there in the public. So, I have just three language revision suggestions. But before I get to that, does anybody have any questions about how OPR interacts with those records or any of our processes? Yes, sir.
How you doing with the backlog?
Oh, I'm so happy you asked that.
Most people
No, that's not sarcasm. So actually,
No, I didn't take it.
yeah, I actually used to be the chief prosecutor in the enforcement unit, and I started in that unit in fall of 2021, and we had a 1,200 case backlog, cases that had been pending for years. I'm happy to say we don't have a backlog anymore.
Beautiful. Nice show.
Yeah, we're really proud of that work. It was such a huge team effort at OPR, and we were really supported from the Secretary of State's level all the way through our through our director. And we did a lot of work to get rid of that backlog. And now I'm really happy to say that most of our cases are adjudicated within about a year. So that's a huge accomplishment for our agency.
Mark.
So one question I have is I've actually had opportunity to work with your office before in terms of filing a
Wayne?
complaint.
Okay.
And also I'm wondering if somebody does something wrong, like seriously wrong for their profession.
Yep.
And I'm thinking nurses and medication.
Sure. Diversion of medication.
Yes,
That's a common one that we
want
see.
that, yes. With sealing, do those charges change on your site? So if somebody were trying to hire a nurse for their childcare center, let's say.
Yeah. So
Yeah.
that's a great question, and I'm glad you asked it because we do in our disciplinary process really try to focus on charging the underlying conduct and not the conviction, because we've seen this, expungement was such a big concept that everybody was really jumping on board with a few years ago when we realized oh, this would really be hard for us if all we were charging was the conviction. So now what we do primarily is charge the underlying conduct and not the criminal convictions. We do sometimes, though, still have to charge criminal convictions, and it's primarily in the context of people who have lied to us on their applications.
Mhm.
So when people don't want to disclose that they have a criminal conviction, and there are all kinds of attestations at the end of their application saying, I swear this is true, and I understand that I'm subject to perjury and all of that if I give false information. So if they don't tell us about a conviction that they had that's not expunged, and we find out, we charge them with failure to disclose a criminal conviction. So in those kind of cases, it's hard, that's the conduct, is not disclosing a conviction. But that's really the main circumstance where we're charging convictions these days. Most of the time, we're really charging that underlying.
Many years ago, I know that there were certain professions where there wasn't necessarily a thorough sort of analysis of if somebody with a criminal record could go into that field. And so it sounds like things might have changed. So for example, hairdresser, somebody had told me that hairdresser, you couldn't have a criminal conviction, and yet there was a program in the facility.
Yeah,
Okay.
sure. In correctional facilities where people
Right.
can. So I've been at OPR since 2017. It's never been the policy of the agency in my time there that if you had a conviction, it was an absolute bar. And in fact, as far as I know, unless the conviction again was really a serious felony where the public's potentially in danger, or unless it's really related to the practice of the profession, then it would not have been a bar, as far as I know. I think we've really been on the forefront of the idea that people deserve a second chance. People deserve a second chance, and we're all human and we all make mistakes. So as far as I know, that's always been the philosophy of the agency.
Great. It sounds like and I appreciate how hard it is to balance this is really serious.
Public protection
and let's look at the circumstances.
Exactly.
And see. So, yeah.
Yeah. And I could talk about this all day, and I promise I won't, but coming from the enforcement unit, I can tell you that our investigators and our prosecutors and our enforcement teams really do balance, the circumstance of the case and aggravating and mitigating factors. And mitigating factors are really an important thing to consider when you're looking at whether you want to do public discipline on someone's license that's going to be there and that the public can see kind of in perpetuity, you know?
Yeah, go ahead.
As you're about to go into the next
Yeah,
part,
yes.
I want one clarification,
Sure.
which will help. I really appreciate the broad sort of, because I don't really know very much about, about PR, so it's very helpful. Is in the investigations and documents and stuff that are posted when you do one of those investigations, how does that include criminal records? Like, would it have like the docket or the probable cause affidavit information, and would that be something that would be posted on the?
Right. That's a great question. So first, our investigations aren't public record. So the only time we're disclosing investigations is when we're doing it to another law enforcement agency. We have compacts that we're obligated to disclose investigations to. And in the process, like where we've charged someone, they get a copy of the investigation. So that's really the only time that we're releasing those investigations. But when we do charge someone with a violation that's related to a criminal conviction, we will often have in there like a docket number. We'll say the name of the crime, whether it's a felony or a misdemeanor, and we kind of describe the crime. So if it is referenced in an order or if it's referenced in charges, that's how it will be mentioned. And then if it's expunged and we need to remove that from the public view, because those orders are posted on our website, we have to contact our web operator. We remove that and then we will redact and then repost, or we might not repost. So that's kind of
Okay.
how we deal with that.
Okay, that's very helpful.
Okay, great. So if you'll look on page 2, and I don't know if you got a copy because right, there we go. So if you look on page 2, we have some suggested language revisions, and you'll see on page 15, line 13, we're suggesting a change to subsection A4, which is about how someone makes a petition for the expungement or sealing of a record. And in 4, what we've added, or what we suggest to add, is the respondent shall file a stipulation with the court, and the court shall issue the petitioner an order of sealing and provide notice of the order to all entities provided by the petitioner and section 7607A. There's another section, there's a reason we've suggested this, and it's because we want it to kind of echo language that we're suggesting in 7607. So kind of the next change that we're suggesting is why we've mentioned this. But the basic concept is that if OPR doesn't, or another licensing agency doesn't get notice of an order, how are we to know that we need to seal or expunge? Like, that's really important. And we actually would like to have the order itself, because our agency is very geared towards transparency, and public records are a big part of what we do. So transparency to the public is very important. So if we're going to take something out of the public view and it's not going to be part of a public record, we really need to see the judicial authority for us to do that. So that's kind of why we're suggesting all of the changes that we're suggesting. So the next one that you'll see is on page 23. And that is to section 76. Oh, I'm sorry.
Before we move on this one.
Yes.
So the language that you're suggesting is saying that the petitioner needs to identify OPR.
Yes. Well, there's a couple of ways it can happen, because OPR has certified law enforcement officers as some of our investigators. So if they're investigating, for example, a nurse who is engaged in diverting narcotics, that may also be a criminal case. So they have law enforcement authority to cite someone for a crime. If our investigator is the citing officer, then the court automatically sends us the expungement order, because that law enforcement officer has to go into Valcor to do things to those records if there's an expungement. So if we're the citing agency, we get notice. If we're not the citing agency and the petitioner doesn't say something, we don't know. And
So I guess my question is, does the petitioner, so this is somebody that has some license that you are regulating, right? So they go, they get their request to get their record sealed, it's granted. So do they know that you have stuff on, they've been informed at one time, so they know it's up on your system.
they disclose it to us. They've been a participant in our disciplinary processes. So they're well aware when we're referencing a criminal conviction in one of our orders, they've been there every step of the way if they've chosen to be. If they don't choose to be, we still send them the orders. And so they should 100% know that that's out there.
Okay, but there could be that the person forgets, oh yeah, I forgot OPR is gonna have this. And so it just, the responsibility then is on that person.
It's on that person. Yeah. And something that I was kind of contemplating as I was thinking through S12 is, could there be a way where OPR is kind of connecting with courts and prosecutors, also to make ourselves more known and make this issue a known thing so that they will be more aware. And it would be great if somebody could say to the person, do you have a professional license, that's regulated by OPR? Or do you have a license from BDH to be a EMT or something like that? So if courts were more aware and prosecutors were more aware, that would be an you said you did.
Chase.
Sure.
I'm sorry, I'm in that space at the moment. And it is in the best interest of Vermonters. It's in the best interest of the licensee as well, that their ability to do their work is protected.
Mhm.
And the Vermonters receiving the services are protected as
Yeah.
well.
Correct.
It's up to us as policymakers to ensure every time we can, it's communicated well.
Yes.
So if it makes sense, why don't we do it on the front end, which is in this policy state that there would be, I know some of my colleagues don't like working groups, but this is a situation where it's imperative that we do this. Because just listening to the questions that, fellow committee members have mentioned,
Mhm.
and then knowing how they intersect, especially when I think of my key area, which is education,
Mhm.
and how, we've got in a school district, I'm thinking about the correlation, with OPR. We have the whole school district licensing piece. So we have teachers, administrators licensed. Then on the other side, we have professionals, we have speech pathologists,
Mhm.
we have.
Those are OPR licensees, school nurses,
Okay.
mental health counselors that are
Okay.
working in schools. Correct.
So you start going down that road and all of a sudden there's a lot of intersectionality.
Mhm.
And if we're not very clear in helping everybody with that communication,
Right.
we're going to have those lapses. And it could happen that one of those lapses comes back and hurts.
True.
someone.
And y'all may have heard also that there's S-119 about the licensure of early childhood educators, which is a big report that OPR did. And that's actually been added to the OPR or being added to the OPR bill. But that's another really important space where making sure that everybody is clear about what the agency's obligation is, what a petitioner's obligation is to disclose. All of that is really important to make sure that we are all on the same page about how criminal histories are out in the world. Agreed. So, okay. So we have another change or a suggested revision, and 7607 kind of really gets to the heart of that. And that's on page 23 and 24. And I think it starts at the bottom. If I'm using the correct version, 7607 is about the effect on ceiling. And if you go to page 24 at the very top, this is where we have a suggested revision. So, but I'll start on page 23. So the court shall send a copy of any order sealing a criminal history to all of the parties and attorneys representing the parties, including the prosecuting agency that prosecuted the offense, VCIC, and then you flip to the next page in the arresting agency. And then we'd like to insert, we suggest inserting any other entity identified by the petitioner that may have a record subject to the sealing order. And that's going to be a help to OPR. That language is going to be a help to the judiciary, and it kind of puts responsibility on and empowers that petitioner to, say if they've got some criminal records in a state agency that they would like for the court to send it there. So we think that that's an important change.
So either that or the court, under this current language, should probably be sending this to OPR, to the Department of Health, Vermont Department of Health, et cetera, every time they seal something. But it kind of would be a little easier if the petitioner identified him.
I mean, I just want to.
They're not sending those things to you now?
No, the only time we get one is when our certified law enforcement they're the investigating person and they've cited the person for the conduct. But like if,
I'm sorry, go ahead.
well, I was just going to say, if we're getting every single sealing and expunging order that happens in the state of Vermont, our agency, and I'm sure VDH would be completely inundated.
Nice point on that as well. Karen and then Ian.
So I can agree that is try going too far the other way.
Yeah.
I guess I am concerned that there might be folks who are just like, forget. Like, no, you're in this process of filing for this petition. Maybe not. And forget, I should let OPR know. I should let Department, who are these entities? I'm guessing there's like a standard list of them, like, but can we put that in legislation? Like, I just would want something like on the form or the petition or whatever that's like, should any of the following be notified?
So I don't think we necessarily have to put in legislation, but we'll have Judge Zone comment on this. I mean, sometimes we pass legislation with the understanding that forms are going to change without us directing that, because it's going to happen. And that makes sense. I mean, if there's only so many entities, have a checkbox on the petition, because it's a form.
Right.
So, and I heard you say that you would be happy to cooperate to help.
Oh, 100%. Yes.
So I don't think we need to put in legislation with, as long as we have this understanding. And in the past, that's not been a problem. Forms have changed. Yeah.
That was mostly, I think, like what I was thinking was, could we basically have on the petition some identified ones already so that you don't have to generate it on your own? I think that my concern about it is one of the things that we haven't talked about is the timeline. So like, when was this investigation? And
Exactly.
it was 10 years ago,
Right.
So now you're asking somebody like 10 years from then to remember like all the different people who maybe have a record of this. So putting it entirely on the petitioner, to me, I think it's a little difficult I agree with the, like, you want to have accountability there. And so I guess my question to testify is, yeah, do you think,
That's a reasonable burden to put on someone.
yeah,
I mean, that's kind of what I'm hearing from your question. And look, when someone goes through an OPR process where their professional license, the way they're making a living
Yeah.
is being disciplined, I would hope they remember that. Maybe they won't, and that's fair. But otherwise, how are we going to know? I mean, that's the thing. It's like, if the burden's not on the petitioner to speak up, then how's a court going to know? How's OPR, how's BDH going to know? So I'm not,
It's a lot of burden on these agencies if they're gonna get the
yeah,
thousands.
yeah. We heard that they do thousands of them. So yeah,
And people know if they need a professionally, like it's.
they renew. Oh, and let me just say, thank you so much for mentioning that. I should have said this. So if you have a professional license at OPR, you're renewing every 2 years. And on that renewal form, you're saying, I'm swearing and affirming that since I last renewed, I haven't had any new convictions, or if you have, you're disclosing them at that point. So that is part of the ongoing conversation that we have with licensees as the regulator. So
you're interfacing with the for people who have license, like, in their lifetime as a licensee.
so many times, every 2 years.
Yeah, okay.
And yeah, so and of course we don't regulate lawyers, we don't regulate MDs, we don't regulate teachers. So there are certain groups that we don't regulate, but we do have the bulk of occupational licensure regulation in the state.
But what's fascinating in that is that when you're multiple licensed as an individual,
Mhm.
you can have that. At one point, I had 13 different licenses. And,
Wow.
so, and they crossed a lot of spectrum.
Right.
Just because, a little weird that way. But, so that's to your point.
Yeah.
You should know, when you're dealing with that.
Yeah.
And so there's a certain amount of responsibility that is on, the petitioner. And then, with the fact that, this is Vermont, and we are in a unique situation where people are willing to work towards communicating well.
Mhm.
And that's to Martin's point,
And we also are lucky that we have these kind of progressive policies where we want people who may have made mistakes in their past. We're happy to help them get into the workplace. Like, there's a lot of value there. So we don't want to be an unnecessary hindrance. So again, it's that balancing and making sure that we have policies where we're all accountable. So OPR is going to be accountable for making sure that we're sealing and expunging orders, but we have to know about them somehow in a way that makes good administrative and financial sense. Because if we were getting thousands of these, we would have to hire more people. We would have to increase our IT systems, and all of that would cost a lot of money. So so I had one more suggested revision, and that's on page 28, line 20. And again, it's where we're talking about the effect and process of sealing. And that is in subsection 4. So it's at the very bottom, I think, of 28. So when a sealing order is issued by the court, any person or entity except the court that possesses criminal history records, and then our suggested addition there is, and that has been provided the sealing order either by the court or the individual whose record was sealed, shall, and then it tells what our obligations are. So, and one of those obligations is to bar viewing of the sealed offense. And we suggest the revision of adding in any publicly accessible database. So we do have a database that's not publicly accessible, that's just got licensing records and, and we also have a public facing one. So it makes sense that we would have to remove it from the public facing one and take measures there. But getting the sealing order, again, is a critical component for, I think, administrative agencies. And if we, again, we're taking something out of the public view, which public transparency is very important in this state. So if we are going to do something that's going to impact the public's access to information, we should have a copy of the order so that we can see for ourselves rather than somebody telling us. Or we get something from the judiciary or something signed by the judiciary that the petitioner can hand us. So.
Karen.
So I appreciate the piece of adding the publicly, except like, that makes sense, but I am curious then, who can access the non-public version? And I'm guessing there are parameters and rules.
Yes.
Like, I just feel like that's important to.
It is important, and there are definitely steps that we take to ensure that, different people have access within our agency to different things. So licensing folks won't necessarily have access to enforcement information. And enforcement folks, I think they generally do tend to have access to licensing information, but not all of it necessarily. So what I would say is that, within our agency, those are the only folks that are going to have access to our system. And we have measures in place where we can put warnings like, do not disclose records or, kind of that big red flag within our agency so that we can make sure that we're not running afoul of an order that we've received from a court. I mean, that we do have that, we'll have that obligation and we take that very seriously.
Yeah.
So the first part of the proposed language for the process for either by court or by the individual. So that kind of is the first time that we would be creating the potential for someone to like individually deliver a record, an order to you.
Yeah.
Either the language just as proposed or with the language that you've added in up to that point, it sort of is like, it's a court order. So like the court is delivering this. Or at least
But we're not getting them necessarily.
When you get them, when you're the investigating entity, do they get to you from the court? Like
they get to us from the court. Also, I think there's, folks are, when they're renewing every 2 years or when they're applying, they're also giving us criminal records. So I think that there have been circumstances where someone has said maybe to us, I have an expunged thing. And we didn't necessarily get a record of that from a court, but we would ask the individual, like, can you give us a copy of that?
Yeah.
So.
Okay. So that's.
And again, we're interfacing with licensees every 2 years. So like, we're happy we take information from them all the time. They're swearing when they fill out an application, that the information they're providing to us is accurate. So that's an opportunity for folks to provide us with something.
Yeah.
Karen and then Coach.
Yeah, so this is all of once you already have access to somebody's records, how you address them once they've been sealed. And I'm curious, maybe this was covered at the beginning and I missed it. Do you have access to sealed records? No, and you're not looking to get that access or not?
No.
So you can get access to it if the person, like you just said, something with the expunged one, if they offer to share it with you directly.
If they offer to share it, but let's say someone's not yet a licensee and we don't regulate them and they have a crime that's been expunged or sealed. When they answer the question on our application, they say no. If we say, do you have a criminal history? Do you have a criminal conviction? They're going to say no. So there's really not a need for them to provide us with anything because they're answering no. Now, if somebody doesn't understand what they're allowed to do or what they're not allowed to do, and they inadvertently say, yes, I had one, but it was expunged, then they're going to give us the information and they're going to tell us it was expunged. They're going to give us that order. And then we're going to say, we don't know about this because we're not going to consider that in the licensing determination because we don't need to know about this. And then we're going to kind of follow the same protocols if they've given it to us. Like it's not going to be publicly available. There's going to be a warning on their licensing profile, and we're going to redact documents and all of that.
And this is just different from last biennium. Weren't we looking at, okay, this is different. So you're not asking for that at
We're
all.
not asking.
I was
for
like
an
looking, is
exception.
there another piece or
Nope.
something?
This
Okay.
is it.
This is all after you have a record on file and it becomes sealed. How do you?
How do we manage that? Yep.
Cool.
So if we make if the needed corrections or suggestions, and we take those. I'm just wondering, and this is a general question, I think, to all of us, is at what point do we check in, on the progress, Mr. Chair?
You're asking me that question, so I have to pay attention to your question? I was busy talking about next week with Nate, sorry. So no, I heard you. So what you mean, what's the next step on this yeah, I think that we'll incorporate parts of this. I have a couple of questions before we'll do that. Most of it seems fine, and we're going to get some additional testimony on this and other changes that we're making to the document, maybe towards the end of next week, because our legislative council's out earlier in the week, and so it might not be next week, but the following. So,
Because I'm just, it really makes a lot of sense. And when I remember hearing, a report when the secretary came in and talked about the total number of licenses, and when we were doing some work on the military.
Yes, removing barriers. Mhm.
And, it started, the volume was just incredible, the numbers. So I'm just wanting to make sure that, we have a way to cross-check the veracity of it.
Mhm.
We'll have to keep thinking about it.
Okay, happy to be part of that conversation if you want us to come back, or if there's something that you'd like for OPR to kind of consider and weigh in on. Happy to do that.
yeah, go ahead.
One other question. I think just going back to just talking about what you're going to seal, like what part of the record you're going to seal if you get an order.
Yeah.
So you got an investigation that's private, but then the thing that you put up online could
order.
reference the order. Thank you. I'm trying to get the terminology right. The order could have like a docket number referenced. It could have a court case, something like that.
Right.
But like, could there be a narrative in there that is basically talking about the same underlying criminal event, but just
Conduct. Yes.
yes.
So we definitely do have that. And sometimes we don't even mention the conviction. We're just talking about the underlying conduct.
So what
And-
happens if you get a petitioner thinks back and says, oh, OPR did an investigation and sends you one of these, and the document that's up on the website doesn't reference a docket number, but just has a long explanation of the conduct.
Of the underlying conduct. And
Yeah.
my understanding of sealing and expunging is that we're sealing the fact that someone has a criminal conviction, a criminal record. So if there's underlying conduct, let's say someone committed a serious assault on someone else. And that's something that we're going to charge. We might include a description of that conduct without any reference to the criminal record, and we would not use the criminal record as any kind of evidence in that case. But, you know, again, it's that public protection piece of someone's asking for the state's authority to engage in a profession. And it's the state's kind of stamp of approval that this person is safe and qualified. So if we think there's conduct that they've engaged in, that the public needs to know about as a matter of public protection, we are going to mention that. And my understanding of this is that this statute isn't a bar from us mentioning underlying conduct. We're just not referencing the criminal records or case.
And I don't think it would be to bar you from mentioning it. It's more of a question of what do you do when there's an order to seal.
There would not be any sealing because it doesn't reference the criminal record or the criminal conviction. So like, now if we wouldn't also say like in a description, police officers responded to the scene and took someone into custody. Like we wouldn't have any discussion of that. And if there was discussion of that, that would be taken out because we wouldn't kind of want to hearken to a criminal process.
It would be helpful for you to see one.
Well, I'm more thinking of just, I'm not going to testify. It's very helpful. Thank you.
Sure. And if you have follow-up questions or whatever,
Say what you're thinking and then ask the question from that.
Well, I think what I'm thinking of, I think that's a very reasonable point, but I want to just keep us in the frame of how long ago these charges are going to have been, right? So,
Yes.
So like, I get absolutely that it's important for public accountability and public safety, especially for people who have license like this.
Yeah.
But we as a state or as a legislature, we're, I guess, going to say that at some point it's appropriate to seal this record. And
Yes.
so if I am trying to seal my record and I also have this long narrative of an event that happened in my life
Yes.
10, 12, 15 years ago.
Great.
So how would you address that?
I'm so happy you mentioned 10, 12, 15 years ago because our unprofessional conduct statute is 3 VSA 129A. And it tells us when we can, what the process is for considering a criminal conviction, whether it's a misdemeanor or a felony. And the more remote a crime gets, the less relevant it is to occupational licensure. So you're 100% on point with that. So if it's more than 10 years, the statute, and this is kind of the same in federal law, if it's a conviction that's more than 10 years old, it's not relevant unless it's like a serious felony.
Which doesn't get expunged.
Exactly. So that's kind of already baked into how we look at criminal convictions and whether we're referencing them. And I did note that this S12, and I actually don't think this is a change necessarily, but there's like after 3 years, some things are going to be sealed, and after 5 years, other things. And yeah, I mean, that is a concern, but we, again, we'll get that sealing order, we'll remove that from the record. And if it's underlying conduct, if it's more than 10 years old, we're not gonna.
Well, and I hear that point. I
Yeah.
think, sorry, I don't mean to interrupt.
No, it's okay. Please.
But at the time of the investigation, it won't have.
It was fresh. It was pretty fresh.
Yeah, but now it's been
Yeah.
a long time.
Yeah.
But that forever record on the internet
Right.
makes it, it looks
And
like.
that conduct may still be described someplace in their occupational record.
Yeah.
Yeah.
Part of asking questions, I don't have to necessarily like the answer.
I mean, thank you for recognizing that.
And I won't bully anyone. So no, but I really appreciate it. It's very helpful.
Great.
So I have a couple of things. I do like the way you've thread the needle on what you asked for last year and what you're asking for this year, which this conversation just came out because last year we were trying to figure out a way
Exception.
for the exception to use sealed records.
Yeah.
And now it's like, yeah, the underlying conduct, but we're not going to talk about there being a criminal record at all. And there's a time frame. So anyway, no question there, but a couple things on the language. I don't know why we need to have either by the court or by the individual whose record was sealed. Maybe that's more of a discussion for all of us. I think the passive voice and that has been provided, the sealing order covers wherever you get the sealing order from. And you're, by having that either by, you're excluding, maybe for some reason, state's attorneys
Wanna send
or
it?
somebody, you know.
That's a great
So
point.
I just don't think you need that language. Publicly accessible, though, I need to understand that a little bit more. So if it just said accessible, you're not able to bar viewing of the document like internally from people?
That's a great question. In our system, when we receive records, it depends on how we receive them. So there's one way where we can version over a record and we could redact and then re-upload. In our system currently, if they're housed in a different way, we can't change the document at all. So
You can put sealed on.
we put a warning. And so when anybody looks up that individual, they have a couple of different views, but we can have a warning at the top and have put on warnings at the top, like indicating, see general counsel, don't disclose records. And then we can also save records as, resave records as, do not disclose, sealed or something like that.
Right, okay. All right. Anything else?
No.
Any questions that we want to throw at Lauren?
We've got some questions.
Thank you for the testimony. That was really.
Thank you. It's a
Oh,
pleasure.
I did have one more question. I apologize. So was this brought up in the Senate Judiciary Committee, this language? Was this proposed? Okay.
It was not.
See, there we have a question over.
I mean, and I didn't know the answer. So
So for the record, for the answer.
For the record, my name is Lauren Hibbert, Deputy Secretary of State. This language was not brought up in the Senate, but we strongly support it being added on that.
Were you guys afraid of taking it to the Senate or you
I
just
think
didn't?
we didn't realize that it was coming.
Okay, right, thank you.
There's a lot on everybody's plates, and so sometimes it takes a little time to
Catch up.
absorb it all.
I was only kidding.
Well, I mean,
But some people.
Sort of.
Yeah. All right, thank you very much.
Thanks so much.
Thank you.
So let's hear from Lauren Lehman next. Thank you for being here by Zoom.
Thank you so much for having me. Sorry I can't be there in person. It's kid vacation week and I have lots of children. My name is Lauren Lehman and I am the General Counsel for the Vermont Department of Health. And here to testify fully in support of everything Jennifer just said and OPR just said. It captures a lot of the department's opinion as well. We also issue professional licenses for EMS professionals, so AEMTs, EMTs, paramedics, etc. We also, the Board of Medical Practice is part of the department, so that board issues licenses to MDs, podiatrists, and several other professions as well. So we have a certain number of medical professionals, healthcare professionals. We too receive, ask in our application process if somebody has a criminal history and often receive criminal history records. And under the Board of Medical Practice statutes are required to post a lot of any felony records for medical doctors on website, on our publicly accessible databases. So just similar to OPR, our biggest concern, the new requirement because there's always been a requirement that the court notify any other entity of the sealing order, but we have never consistently received those sealing orders from the court because the court probably was unaware that the person with the sealed record had, criminal history records over with the department. So with this new requirement that we, as a licensing entity, take actions to remove those, any information, any remove any documentation of the criminal history records from publicly accessible databases, we want to make sure we have notice and that we're able to comply with the law. We fully support and have similar language recommendations as OPR. The questions I was hearing, the individual, we too are very happy to work with the courts on the petition for sealing to ensure that they is an opportunity and a reminder to a person, hey, somebody else might have criminal history records. Perhaps we don't even frame it as, does OPR have criminal history records? It is, hey, do you have a license with OPR? They might have criminal history records. Hey, do you have a license with the Board of Medical Practice? Just let us know. I think that would greatly whittle down, even if we receive notice of a sealed record and that person we don't have any criminal history record for that person, we've at least received notice and we can go from there. So I think that addresses, like, does the person remember if they have a criminal history record that they sent to OPR or to VDH or not? They can, just getting the sealed record, getting the order, we would be able to check, and that would whittle down the numbers sufficiently that the department could handle the volume. Otherwise, just this, again, we're just asking for this administrative fix to help us manage the process and ensure we can comply with the new requirement in S12, and happy to answer any questions.
Any questions?
I have a question
Yeah.
for Chair.
Well, I suppose that's fine. I was looking for questions for the witnesses, but
Yeah, that's fair.
go ahead.
Is there, so we've just heard, I think twice that sometimes people are accidentally disclosing sealed records on these questionnaires, where it asks, like, do you have a criminal history? I'm wondering if there's a way, and it's relevant to this bill in the sense that we're moving towards sealing.
Right.
Is there a way that, at least for government entities, like, who we've heard from today, where we could, when we're asking questions like that, have like a parentheses that says you do not need to disclose sealed or expunged records?
Could, yeah, I mean, yeah.
Susanna's point might help that. But didn't she talk about like what the process is? And I think it could be what the process, like what's included.
Yeah, I just, and I know it's not really relevant for, unless
Well, I saw Lauren nodding her head that as far, and the other witnesses but we could rely on them doing that themselves, or we can put in a section somewhere that, because it's not perhaps just the agencies we have in front of us now, but some language that along those lines. Yeah. So work on that language for us, Ian. Yes.
Is that okay?
Please. Yeah.
Lauren Hibbert and Lauren Lehman, it's so good to see you. Lauren and I frequently would testify together as the Laurens when she worked for the Office of Professional Regulation. So
I think
it's like a reunion tour here.
Last year, I think, as the Lauren.
Sure.
Yes,
That's
now I'm remembering.
We all love each other. So it's Lauren Hibbert who's speaking now, and I definitely think we could add to our application that you do not need to disclose expunged or sealed records. We probably would have to add a definition and like an I bubble or something in our application to define what those are, because it's pretty amazing. A lot of people don't know what happened with their criminal records, so we'd want to make sure to do that. But I would encourage you to also do it in the bill, because the Department of Health and the Office of Professional Regulation are only one of some entities.
Right.
Lots of entities that ask this question. So if your intent is anytime somebody asks for self-disclosure of criminal history, that they explain that you don't have to disclose expunged or sealed, the universe is much wider than the two of us.
Yeah. Thank you for that. That's helpful. No, great. That's great. All right. Any other questions for the witnesses? And Ray, did you want to speak your part as well? I mean, we dragged you in here via Zoom and Lauren took all the glory of testifying and, but happy to hear if you have any additional input on this.
No, I totally agree with everything that I've heard. I started listening about 1:30, so I heard the previous testimony. I'm here just in case there were some specific questions about how EMS investigations, crime records, et cetera, are stored and all that sort of thing. So I'm available for that, but I do not have any prepared testimony.
I appreciate it. I think we're in good, I think we're fine with that, with those questions as well. Anything else for, I think that covers everybody. Thank you very much. I appreciate the testimony from everybody today. So before we adjourn, just to give folks a heads up on what we're doing next week, if I can find what Dave has already given me. And okay. Just to give some folks a heads up. So on Tuesday, we're going to be taking testimony on some additional items that we're thinking about putting in the miscellaneous bill, including language from H36 and some language that we're receiving from corrections. So that's happening then. We'll also that afternoon be voting on the joint resolution number 15. We could. What's that? Oh, no, I just took Michelle off, sorry.
Oh,
You can keep that, yeah, keep the thing on it. Michelle's just not around. Wednesday morning, we might be taking testimony on, it's not even on the wall yet. H511 is the short form bill that from Will Greer regarding immigration access to non-public areas in schools. Will has also been working on some separate language that would fill that out. And it would probably be something that would be added to S44 if that's something we decide that we're going to go forward with. And then in the afternoon, if in fact we have a draft of H193 that works, as I'm looking at Barbara.
I have sent it.
So no, I appreciate that. Thursday is the Fair and Impartial Policing Oversight joint hearing with Senate. And hopefully Thursday afternoon, if Ian gets the language all together this afternoon with Michelle, we'll do S87 or not. And then I'm hoping to vote on S87 and S109 possibly at the end of next week. Anything I'm missing?
3 of us are going to be,
On Tuesday at 1, right?
yes, we're going to be work crew.
You guys have work crew?
We have work crew. So
You guys have work crew. So do you know how long you guys are scheduled?
it's 1 to 2.
Okay, so we'll be doing some of the stuff on the miscellaneous bill. I don't anticipate any of the 3 things being controversial. But we do need to just take some testing.
Just wanted to make sure you had a quorum.
Yeah, well, you can always swing by and get.
That's true. We